activate.
Hear ye, the Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Good morning, ladies and gentlemen. Our first case this morning is 2020-1533, the State of Ohio Bar Association versus Harvey Bruce Bruner. And you will notice that Justice Donnelly is not on this case, and in his stead, we have Judge Christine Miley from the 6th District Court of Appeals. Welcome, Judge. For the respondent, Mr. O'Shea.
Thank you, Your Honor. If it please the court, I would like to reserve 5 minutes for rebuttal, if I may, Your Honor, and may I proceed?
Proceed.
Thank you. If it please the court, Your Honor, Justices of the Supreme Court, let it be known that notwithstanding whatever you've read in the context of the briefs that were filed, that I can speak on behalf of my co-counsel, Mr. Housel, as well as my client, Mr. Bruner, that we have the greatest respect for the board process and what we're doing here today. Given the fact that we had COVID, given the fact that this case took an unusually long period of time, it may appear that there was some sort of disingenuous feeling about our counsel on the other side. Not true. I hope I made that clear in our brief. Now, having said that, if I may, Justices, I would like to address the court on the issues in the matter pretty much as I set forth in our objections. First and foremost, I have never had a situation where a fact witness was blended into somehow being part of counsel. And I speak of Mr. Tierney in the subpoena, where we were not able, in any case I've ever been involved with, to interview, depose, or get information from a purely fact witness. Mr. Tierney never appeared as counsel in this case, but was told or promoted as being someone that is part of the team, and therefore whatever he did was confidential, including interviewing apparently Mr. Walton at one point, including apparently, although we couldn't be clear because we weren't able to ask Mr. Tierney whether or not he in fact interviewed Mr. Ortega Sr. or Mr. Ortega Jr. This court has spoken so many times on the fact that there should be no gamemanship at all. We cite a case, the Stafford case, that talks about that, and that the rules of civil procedure, which I believe Relator agrees apply here, are to eliminate surprise and trial by ambush. So they had information that we thought was relevant. We weren't allowed to see it. And at the very least, I think as we argued in our motions, our brief in opposition to the motion to quash, as well as our, that at the very least, they should have preserved the Tierney records for an in-camera review, be it by the panel chair or by at least this court. I don't even think that was done. So this court, as well as the panel itself, was essentially buying a pig in a poke when it comes to the idea of what was in the knowledge of Mr. Tierney and what did he do. In addition to that, we had the same arguments relative to the Oakley subpoena that we were trying to pursue. Attorney Oakley didn't even respond to the subpoena. Nobody filed a motion to quash. We had to file a motion to compel, and the court just summarily overruled that. Now, one of the big themes of our case being at the discovery phase or during the hearing that we had in October of last year is, and you've heard the argument, due process. Apparently, Relator believes that due process stops completely with the filing of a complaint, and that anything that happens after that, anything, is not part of the due process inquiry. And that's the way I read their brief. So for instance, if someone gets indicted, justices, and thereafter all kinds of crazy things happen in the case, reversible error, the prosecution can never stand up and say, well, look, they read the complaint, they were on notice of the charges, due process has been satisfied. I believe I read the term of the word complaint in their brief about 25 to 30 times. Complaint. They said, we filed the complaint, he read the complaint, he understood the complaint, filed an answer to the complaint, due process was served because of that. But as this court has held, and as the 8th District Court of Appeals has recently held, due process involves two things. You know, the right to go through the evidence in a fair and open way, and secondly, notice of the charges. You get both in due process, both. This court has spoken on it. The United States Supreme Court has spoken on it. Now, one of the things that we consistently heard, and it became somewhat confusing that day of the hearing in October, is, well, are you guys ready to call witnesses? And the fact is, nobody was ready to call witnesses that day, including Relator. There's no question, and they cannot sit here with a straight face and tell this court that they had witnesses in the bullpen ready to go. The only thing that we were going to do on the record that morning was put on the, the consent to discipline, the stipulations and the like. There were no witnesses available. And the vast majority of Relators Counsel, with all due respect to them and understanding their logistics, were people that were in prison. And getting to them like we're doing today through Zoom and the like was logistically difficult, which is why the weekend before the commencement of that hearing in October, that, through the efforts of my co-counsel, Mr. Housel, and the efforts of counsel for the Relator, that they hammered out this resolution that we set forth in the stipulation. So,
Counsel, can I ask, why would it be that the attorneys were not prepared to go forward with the hearing, given that the procedural regulations state that the panel has the option of taking the case on the papers or holding the hearing? Shouldn't they have been prepared to go forward?
I believe the answer to that is yes, with one caveat, if I may, Judge, and that is this. The counsel for the Relator and Mr. Housel worked that weekend to work out these stipulations. As you could tell, they're pretty long, they're pretty lengthy and stuff like that. That consumed their time. I think that every lawyer involved, every attorney of record was unconditionally convinced that there was no necessity to call witnesses. It's sort of like, as we say in our brief, it's like a plea in a criminal case. You come in the morning of the plea and the prosecutor says this is what the plea arrangement is. The defense lawyer agrees. But in this case, using that same analogy, the judge said, no, I'm not accepting the plea. And instead, judge, of remanding it for a hearing and say, come back another day, let's serve due process. Instead, the judge goes, I'm going to find you guilty of the counts in the indictment that the prosecutor wants to dismiss without ever allowing the defendant to have a hearing. And that's functionally what occurred in October of last year at this, at the hearing that we were set for. And I could tell you that nobody who appeared at that hearing as counsel for any of the parties was prepared to call witnesses. As a matter of fact, as I understand it, Relator has the burden of proof. Their witnesses should have been in the bullpen. Ours would come later, but certainly they would have had their witnesses in the bullpen if they believed that everyone should have been ready. And the only witness they called at all was one person, and that was Mr. Bruner. That's it. They had no one else in their picture bullpen, nobody. So I hope I answered your question, Your Honor. But that's what happened. And I don't know how much of the record reflects that, but certainly the transcript that we have from that hearing will indicate exactly what the conversations were and what the expectations were of the folks. So I guess I'm confused as to where that would place somebody like Mr. Bruner, like it's somebody who, even the Relator has indicated in their answer that the nature of these proceedings in front of the board are quasi-criminal in nature. So they have agreed with the thrust of our argument, saying that, Mr. Bruner stands accused in a quasi-criminal type of proceeding, and it's up to relator to prove the charges. In this case, to prove the 8.4 charges that are really the focal point of why we're here today, and they didn't have those witnesses ready to go. They couldn't make their case simply with Mr. Bruner at all. So I guess my suggestion is you ask them, were your witnesses ready? And my understanding from the hard work that Mr. Housel spent all day Saturday and Sunday before the hearing was that no witnesses need to be called. We've got these stipulations signed. We're going to submit them to the panel, and we're going to do this. It's a functional consent to a discipline type of scenario. So nobody, just
the rule states that the hearing panel may accept or reject the agreement. Now, I know it was submitted pretty late, but was it specifically rejected? Because it's at that point that the matter would be set for a hearing.
Justice Berger, exactly my point, and exactly the point of our brief. If the panel didn't want to accept the consent to discipline stipulations, reject it and send it. We'll gladly live with the rejection and have a hearing on the Walton or Ortega matters. We're ready to go. Give us our day in court on that. That's all Mr. Bruner wants. We're ready to try that part of the case. The other matters, all the other cases, I think everybody agreed. We had an agreement there. It's the Walton and Ortega matters and the triggering of this 8.4 violation that really changed everything. It surprised everybody. And I'm not going to speak for Relators Counsel, but I'd certainly surprised myself and Mr. Housel, a very seasoned lawyer, that happened.
Counsel, there is a difference between stipulations and a consent to discipline, correct?
There is on paper, Your Honor, Justice.
Not just on paper, as a matter of legal basis.
Yeah, technically, the consent to discipline actually has a deadline on it,
Yeah.
Justice Fisher. But nevertheless, despite the fact that the deadline had passed, Relators Counsel and Mr. Housel worked out this agreement. So I'm not sure whether we call it an apple or orange. It's still a piece of fruit. And the idea was that this case was resolved. So, and if the panel thought that it shouldn't be resolved on Ortega and Walton, please just remand it in the interest, be it pursuant to the Rule 5 of the Rules of the Government of the Bar or due process. Take your pick.
Mr. O'Shea, the panel chair was using the standard of review as clear and convincing, but I don't find that in the rule. What is the standard?
My understanding is it's clear and convincing. I think everyone agrees that that's the standard when it comes to, certainly with an 8.4 violation. And I see my time, Your Honor, I can't see the clock as well as you do, but I have myself just approaching 10 minutes.
10 minutes? No, you have 3 minutes and 45 seconds left.
With that, total time, Your Honor?
Yes, that's what you have left. Right now it's, yes.
Then I will reserve the rest, Your Justices. Thank you.
All right. Mr. Roberts.
Good morning. May it please the court, Chief Justice O'Connor and other distinguished members of this honorable court. My name is James Roberts and I'm appearing today on behalf of the Ohio State Bar Association. Today I'll discuss generally three main matters. First, I'll outline why due process in this matter was meant and the defendant was afforded all due process protections, and also talk a little about the case law and the facts that support that. Second, I'll talk about the why respondents' pretrial motions were properly overruled. And thirdly, why the sanction recommended by this panel was appropriate. Before I get into those things, I do want to address one thing that was brought up by Mr. O'Shea. The relator in this matter was fully prepared and ready to go to trial. We negotiated a settlement on the weekend before the Monday trial, predominantly on the Sunday before the trial. We didn't reach an agreement until late that Sunday night at 10, 11 o'clock in the evening, the day before trial. We had all of our witnesses lined up, ready to go in the bullpen, ready to testify. We had technology checks with the DRC. We had all of the witnesses that are inmates in the Department of Rehabilitation and Correction ready to go and scheduled to testify. We had other witnesses throughout the state and in other states on standby, ready to go. We were fully ready to prepared and ready to try this case. We had all our witnesses lined up and ready to go. We had no idea until we went in there the morning of October 13th, whether the panel was going to accept the stipulations. So we were prepared and ready to go to trial. At this point, I'd like to turn to the due process issues that Mr. O'Shea touched upon briefly. First, I think with regard to the due process issues, there are two cases, I think, directly on point that shed light on this particular matter. The first is the United States Supreme Court case in re Ruffalo, and second, prior decision from this court, disciplinary counsel versus Reinheimer. First, in re Ruffalo, the United States Supreme Court set out kind of the broad, in that case, there was a situation where there was no charge that was included in the complaint. It was not raised at any time, any point prior to the proceedings in the hearing, and it was based, the new charge was based upon the testimony that happened that day at the hearing. And the United States Supreme Court said that's not due process. Now, if we look to this court's prior decision in disciplinary counsel versus Reinheimer, it gives us a little bit better of a guidepost on what the rules are for procedural due process. And what the Reinheimer court said is that if a defendant, that procedural due process is met if the defendant is put on notice, if the violations are contained in the complaint. In this particular case, the 8.4C allegations were included in this OSBA's original complaint. Reinheimer also stands for the proposition that if a complaint is amended prior to the proceedings, that constitutes due process, and further, that parties can try matters by express or implied consent, even if it's not in the pleadings. In this particular matter, the 8.4C violations with regard to Walton and Ortega were continuously levied from, they were set out in the August 30th, 2019 complaint. They were continuously levied from that point until the day of the hearing. And even during the course of the hearing, Panel Chair Green made it very clear to the respondent during the course of the proceeding that the professional conduct 8.4C violations were still on the table in this matter. And Panel Chair Green specifically said the panel has the responsibility of addressing all information that comes before us. And he went on to say that we do not accept the withdrawal of the charges that relator has not pursued, referring to, among other things, the professional conduct 8.C violations.
Counselor, let me ask you about one of these more specific claims. Did he get all the investigatory materials that he asked for and was entitled to?
Yes, during the course of the discovery in this matter, we produced basically our entire file to respond to it. The only thing that we did not produce are two memos, and Respondent's Counsel mentioned this in his argument with regard to the tyranny issue. So in that particular, those two memos were, one, they were not properly disclosed under Rule 5, Section 8A1, and also they were protected by work product.
Well, let me ask you that, Counselor, because it seems that you're making a work product argument that goes well beyond what the rule allows. Government Bar Rule V8B3 says the summary of investigation prepared by the relator shall be confidential as work product of the relator. All other investigatory materials, any attachments prepared in connection with the investigation shall be discoverable as provided in the Ohio Rules of Civil Procedure. So, as I read that rule, the only thing that's work product in this proceeding is a summary of the investigation.
I understand your question. I think before we get to that, if we look to Rule 5, Section 8, A1 provides that prior to a determination of probable cause, that the materials are confidential and not subject to disclosure.
But didn't he asked these after the determination of probable cause, right?
Right. And so there's two things here, Your Honor. First, Tierney started out with an investigation on a couple of these matters, and then as more allegations, more grievances came in, they were assigned to myself and Mr. Mencken. We began investigating those, and at some point, Mr. Tierney, he's in private practice, he's in Cincinnati. These claims were based out of Cleveland. His investigation was closed down. Those complaints were transferred over to us. So with regard to Mr. Tierney's investigation, I think first, that was closed prior to determination of probable cause. However, even if that's, not the way this court would interpret Rule 5, Section 8.1a, which I believe is the correct interpretation.
Oh, but I don't look at why are we even looking at that? It still would be an investigatory materials under Rule 5.8b3, so it would be discoverable.
Well, even under Rule 5.8b3, there is a provision in there that says that the disclosure of materials pursuant to Rule 5, Section 8.3b are discoverable as provided in the Ohio Rules of Civil Procedure. And the work product doctrine is recognized by the Ohio Rules of Civil Procedure.
Yes. Hold on, but I mean, to be fair, that's a pretty disingenuous argument, because what the rule says is the summary of investigation prepared by the relator shall be confidential as work product of the relator, period. Then all other investigatory materials shall be discoverable provided in the Ohio Rules of Civil Procedure. Now, clearly, that second sentence doesn't say that we ignore the first sentence. There'd be no need if anything that's otherwise was work product was not discoverable, there would be no need for the first sentence in the paragraph. I mean, clearly that this rule gives him a right to any investigatory materials except the summary of the investigation.
So I think the difference here, let me just back up and add some facts in here to clarify this particular issue. Kevin Tierney is a member of the Ohio State Bar Association Certified Grievance Committee. He's an attorney licensed to practice law. When he initially looked at these matters, everything that was gathered in the file has been produced. These two memos, however, were work product in which he was relaying information and advice to the committee based on his legal impressions of the scenario and his analysis of the particular matters. And those are the very definition of work product,
but this work product its own definition. The only thing that's work product is the summary of investigation prepared by the relator. The rules seem pretty clear that he's entitled to that. So why not give it to him? Why wouldn't you?
Well, I respectfully, Your Honor, I believe that I don't think that the proper interpretation of Rule 5, Section 8, A3 is that the only document in anywhere in a case like this that's not disclosable is the summary of investigation. I think that the rule clearly says that it's governed subject to the rules of civil procedure.
So we should just ignore the first sentence in there. So what would be the point of the first sentence under your reading?
Under my reading, the first sentence specifically says the summary of investigation does not have to be disclosed. Everything else in the matter is governed by the rules of civil procedure, and the next section of that rule specifically says that. And if we look to the rules of civil procedure, work product is codified in Rule 26B3 of the Ohio Rules of Civil Procedure, and I do not interpret that rule as basically obliterating the concept of work product in these matters.
Counsel, are you saying that this document that we're talking about here was attorney's advice to the panel or to the investigative team about the legalities of the activity?
Yes, that's exactly what I'm saying. It was a
Then
memorandum.
that would be an attorney-client argument. That's not what you asserted, right?
Well, I mean, I think that the recommendations themselves in there are attorney-client privilege, but I think the whole document is work product, which I think both are applicable in this case. And, you know, in terms of the work product issue, you know, these are opinion work product. Not only some parts of it are privileged, but there's also opinion work product that receives near absolute protection for disclosure. And even ordinary fact work product, you have to show good cause to be entitled to turn over the work product, and that requires a showing of substantial need for the material, a showing that the material contains information that is important to the preparation of the party's case, and that the material is unavailable elsewhere. And the respondent had made
under the civil rules, I almost feel like you're conflating the civil rules with 16B1G and the criminal rules, because the onus is on the party that's not producing to show why they're not producing it. It's not just automatically assumed work product, and then the other side has to overcome some burden here.
Yeah, I think we were required to give them, we identified the two memos, we identified the author, we identified the addressee, we identified the date, and the general subject matter of the memo, which I think is, you know, what's required to be turned over. And they provided absolutely nothing for a showing that there was any showing of need for this material, or that, you know, it was relevant, or that anything to overcome either the attorney-client privilege or the work product privilege.
Counsel, in reading the recommendations and the report, there, I think on two separate occasions, I read that the respondent was offered the opportunity to proceed at the hearing and chose not to, with the presentation of witnesses or evidence or et cetera. Is that accurate?
That is accurate. During the course of the hearing, Panel Chair Green made it very clear that he was not, you know, he was not accepting the withdrawal of all the claims, that everything in the complaint was still on the table. He informed the parties if they had any other evidence that they'd like to put on with regard to those matters, that they were able to do so. However, you know, he did specifically say, if you're going to put on any evidence, it needs to be put on today. And Counsel O'Shea had specifically asked him questions about that, about whether or not he'd be able to present additional evidence. And Panel Chair Green was very clear that once the proceedings are closed, there would be no more evidence. He did leave it open for mitigation evidence to be offered up. But other than that, you know, at the close of the hearing, Panel Chair Green made it very clear that there would be no additional evidence that was allowed. And also,
right, well, counsel, let me ask you then, you were ready, the relator was ready to, I guess, dismiss some of the charges, and the panel did not accept that. Is that my understanding? Is that correct?
Yes, Your Honor.
All right. Did you then put on evidence of those charges to support the charges that were not going to be dismissed?
In our direct, we did, or in our questioning, Mr. Bruder, we did not specifically go into those things, but there are matters within the stipulations and the exhibits that do establish that these violations did in fact occur. There's sufficient facts in the record that these violations occurred. Additionally, you know, the panel was able to, the panel specifically asked some questions about, you know, matters outside the stipulated matters. And
ask that of whom?
Of Mr. Bruner when he was on the stand, the respondent. Panel member Caruso asked him questions about many of the the items that were, outside the stipulation and, specifically asked him about those things. Mr. O'Shea objected during the course of the hearing, and Panel Chair Green said, no, we have not accepted the stipulations. The panel is still evaluating those charges. They're still on the table.
So your position would be combining the stipulations along with the testimony of Mr. Bruner. There was sufficient evidence to have this conclusion by the board and its recommendation.
Yes, Your Honor, that's absolutely correct.
All right, and then after Mr. Bruner was questioned, I guess his counsel had the opportunity to present evidence. Did his counsel question him, his own client?
I do not believe that he questioned his client. If I don't recall for sure if he did, it was limited. But in this particular matter, I think it was pretty clear that well, first off, with regard to the Walton or Ortega matters on the 8.4C violations, there's evidence in the stipulations, in the stipulated exhibits, from Bruner's contradictory testimony in his deposition, his interview, all of which were properly admitted in this matter. In addition to his hearing testimony, there's sufficiently adequate information to find that there's conduct establishing those violations on the part of the respondent. And additionally, I think it's also important to note that I don't think that the panel found him credible when he was testifying in the hearing. Prior to the hearing, Mr. Bruner had already provided 2 or 3 different stories or recitations of facts on some of these charges during the course of the hearing, and they were changed. Some of those prior recitations of fact were changed during the course of the hearing to provide yet another kind of accounting or story of what happened on some of those things.
Ms. Roberts, did the panel specifically reject the consent to discipline or any of the stipulations?
No, the joint stipulations were not rejected at all.
Okay, and what about the consent to discipline? Was that rejected?
There was a recommendation by a joint recommendation on sentencing that the panel, based on the additional violations, went with a different sanction. Does that answer your question, Your Honor?
Well, I just, what I'm trying to get clear is the panel proceeds to a hearing when it rejects basically the settlement agreement between the parties. So did it reject that agreement?
No, Your Honor, it did not reject the agreement. It found violations for everything that was in the stipulated agreement. And additionally, based on the evidence that was in the record and Mr. Bruner's testimony on the day of the October 13th hearing, found 2 additional violations of professional conduct rule 8.4C with regard to the Walton matter and the Ortega matter, in addition to what was stipulated.
Thank you.
Counsel, there was no consent to discipline, was there?
No, Your Honor, there was not. There was a stipulated agreement entered into the evening before trial.
And that's very different in these proceedings than a settlement.
I believe that's correct, Your Honor. Yes.
Thank you.
Thank you.
Thank you. And I see that I'm over time, but
You are.
okay. So I respectfully request that this court approve the Board of Professional Conduct's recommendations, and I'm happy to answer any other questions that you may have. If not, thank you very much for your time.
Thank you. Mr. O'Shea.
There we go, Your Honor. If it please the court, to answer your questions, Justice DeWine and Justice Bruner, on the tyranny matter, I don't think you got a straight answer. In fact, the law that the Relators Council speaks of requires 2 things. 1, they carry the burden, and secondly, they proffer what the documents that they're trying to protect on the record in camera so that the judge or the panel can make a recommendation, which could be reviewed by this court. You don't know what those were because they were never proffered. The biggest question, let me speak about the Reinheimer case. I read the Reinheimer case last night. The Reinheimer case says the exact opposite that what Relators Counsel is trying to tell you. It does not say the mere filing of a complaint is sufficient for due process. It said the exact opposite. So why they keep hammering away at Reinheimer as being supportive of their arguments is confusing to me. And one of the things that I heard is somehow I believe this court needs to say whether or not the board under the rules can start examining exhibits before the commencement of a hearing, because that's clearly what Mr. Caruso had done, because he started referring to things that had not even yet been presented or admitted into evidence when asking Mr. Bruner questions. The stipulations had only been presented to the panel really about an hour or so before the hearing commenced in October. So there's no way that the panel was able to review 50 to 60 exhibits in an hour. So somebody had begun to commence the review of exhibits prior to the commencement of the functional trial. We have a problem with that. And I think any defendant in any case in America would have a problem with the jury being shown exhibits before the first witness is called. The question that I asked myself last night, and I asked this panel to consider, is does Mr. Bruner or anybody, any lawyer like Mr. Bruner, have less constitutional protections than Mr. Walton, Mr. Ortega, Mr. Harb, Mr. Russell, Mr. Jackson, Mr. Herring, or any other criminal defendant? According to Relator, he does. Less. He gets.
All right, counsel, let me ask you some of the, about what was, when I asked the Relator about what evidence was presented, it was the stipulations that was before the panel, as well as your client's own testimony. Is that correct?
That was what I believe the Relator believes the evidence is, but the panel chair, Mr. Green, Justice O'Connor, made it very clear on page 76 of the transcript, it's attached to our brief, that they can consider anything.
Anything what?
That the panel could consider anything, be it in the stipulations or not. All right,
counsel. They had a combination of the stipulations. There were some charges that they wanted to pursue that apparently the Relator would have been satisfied not pursuing, and or some violations, I should say. The panel then asked your client about those violations, and his testimony was the basis for their findings.
May I respectfully disagree, Justice O'Connor, because the transcript is everything, and we cannot have we cannot have Mr. Roberts tell you what's in the transcript. We can only look at the transcript. The transcript was attached to our objections in its entirety. I asked the court to look at the transcript. Don't take my word for it. Don't take Mr. Roberts' word for it in argument. The transcript tells us everything. That's why we have them. And on page 76 of that transcript, again, may I direct the court to take a look at that again, because the panel chair said, the panel get to look at everything, stipulations or not. And apparently Mr. Caruso proved his point when he started asking Mr. Bruner about exhibits that he clearly had started reading before the commencement of the hearing. That completely blew due process out of the water, completely made us all unprepared, including Relator, for what was going to happen. If they
All right, counsel, let me ask you the final question then, because you're over your time. You said that you were not, I got the impression from your, previous presentation that you were precluded from offering testimony here. Is that your position?
I don't want to get involved with semantics, Your Honor, and please take the, we were ready to try Walton and Ortega. That weekend before we reached a deal, they were going to back off on the 8.4C parts of Walton or Ortega for reasons that we set out pretty clearly in our brief. But when we came to the hearing, we thought it more of a plea, and obviously we go second, Your Honor, and if they were going to rest their 8.4C violations solely on Mr. Bruner's testimony at the hearing, as well as the exhibits, whether they be part of the stipulations or the exhibits that have been filed for the board, and which are part of the record here, prior to the hearing, we just don't know the answer to that question, Your Honor. And it's the board's decision doesn't make that clear, whether they're looking at exhibits that were filed before, that were part of the stipulations. And I asked the court to take a look at Mr. Bruner's testimony under oath. He was never asked about the 8.4C issues on Ortega or on Walton. He was never asked about that.
Counsel, maybe just yes or no. Were you precluded? Was it your decision as the attorney not to present evidence at this panel hearing?
Absolutely.
It was.
Mr. O'Shea,
Okay.
Mr. O'Shea, I need to follow up. So the stipulated agreement, did you consider it a consent to discipline?
Absolutely. A functional consent to discipline, everybody did. That's why we had stipulated sanctions, stipulated exhibits, all of the above, your Justice Bruner.
And the
All of it.
document and the documents that the panel was reviewing, were those documents previously filed in the record?
They are. As a matter of fact, they are referenced in the docket 394151 of the docket board docket that was sent over to this court. The filing of those exhibits occurred a couple of days before the October hearing.
Thank you.
Thank you. We'll take a matter under.
Can I ask one, I'm sorry, Chief, can I ask one quick question? Is there anything, are the documents that are allegedly work product that we were discussing, were they proffered? Are they in the record anywhere?
Absolutely, we're not. And I if you excuse the expression, Your Honor, I complained and whined about that consistently in the motion practice.
You asked for it to be proffered?
Absolutely. It's in our motion, in our brief in opposition to their motion to quash.
All right, thank you. We'll take the matter under advisement. You'll be notified of our decision.
Thank you. Still don't say anything, guys. They're still on mic.
Our second case this morning is 2020-629 Cleveland Botanical Garden versus Stacy K. Worthington DeRine et al. For the appellants, Mr. Fellerhoff.
Good morning, Madam Chief Justice. May it please the court. My name is Matt Fellerhoff, and I appear on behalf of the appellants and cross appellees who are various heirs of their ancestor, Jephthah Wade. Jephthah Wade donated 73 acres of land to create Wade Park in Cleveland, Ohio. I request the opportunity to reserve 4 minutes for rebuttal. Ever since Jephthah Wade's gift in the 1800s, and ever since the Barris case was decided in 1885, my clients have worked with the city of Cleveland to try to assure that the intent of Jephthah Wade's gift and was followed, and it all worked for the benefit of the beneficiaries, the public. That has happened throughout this period until this matter arose. This matter arose when CBG initially approached my clients seeking to have my clients sign what was called a deed of limited release to allow CBG to charge admission to the property. What occurred was that deed of release actually included a total release of all rights for my clients of enforcement of Jephthah Wade's gift. They became alarmed by that. They became even more alarmed when a letter was written by the president of CBG indicating, apologizing for that misrepresentation, but then suggested her appreciation for Wade Park, describing Wade Park as that beautiful lawn beyond CBG's gates. CBG's gates, obviously, as this court is aware, included part of Wade Park. Then my clients were sued. My clients do not contend that a garden cannot exist in Wade Park. They do not seek to trigger the reversion. They only seek to enforce the agreement that was reached between the city of Cleveland and Jephthah Wade when it was established in the 1880s. They've spent hundreds of thousands of dollars, not for their personal benefit, but to assure the public's right to use the park. They had to do this because the city of Cleveland won't do this. In response, the city doesn't argue that it is trying to stick up for the beneficiaries, to assert the beneficiaries' rights. The city of Cleveland is asserting that it doesn't have to, that there is no agreement that requires the city of Cleveland to comply with the grant.
Council, why is this not open to the public?
The property is not open to the public because it has been fenced off. And that's a layered issue. It has been fenced off by the Cleveland Botanical Gardens because the city of Cleveland changed its policy and allowed the Botanical Gardens to fence off the property and charge admission. And it charged.
Right there, open to the public. Is there a phrase in conjunction with that that says free of charge?
It does not say that, but it is supposed to be open to the public at all times. And as is detailed in our brief, it is only open to the public, not considering when the public can pay money for the benefit of the Cleveland Botanical Gardens, less than 25% of the time. And that math is in the brief.
Right.
But the other issue is what has happened to those 11 acres. Not only is it supposed to be open to the public at all times, it also, the deed requires that the grant is only for park purposes and no other purposes. And what has happened here is that the city of Cleveland is charging the public admission charges to enter the city of Cleveland. The beneficiaries are the city of Cleveland citizens. The citizens who own the property are being charged admission to enter their property for the benefit of CBG. CBG.
So, let me ask you a little bit about both those things. So
Sure.
I'm trying to understand what you think open to the public means. So I mean, I take it from your calculation that it's only open to the public 25% of the time, that you think to be open to the public, it has to be open 24 hours a day. Is that 24 hours a day, 7 days a week?
According to the rules of construction of a grant, especially one by a private devisee, the interpretation of the grant needs to be strict. The requirement is that it be open to the public at all times.
Just tell me out though, does that mean 24 hours a week, 7 days a week?
It does mean 24 hours a week, 24 hours a day. It's been like that for 70 years. Your Honor.
I mean, isn't it pretty routine for parks to have curfews? I mean, people generally don't feel good about people in parks at 4 a.m. And I mean,
Your Honor, I
couldn't say you can't be there after sunset.
I think what you're getting at is the conclusion that was made by the 8th District in the trial court about regulations that the city might impose.
I'm just trying to understand what you said it's only open 25% of the time or something. I'm just trying to understand what you mean, what you think open to the public means.
But the 25% of the time is not just a curfew in the evening. It is closed on Mondays.
Could they have a curfew?
Well, Your Honor, that isn't in the record.
I'm asking you. You have a meaning that you think this phrase means. So I'm asking you, under your understanding, could they close it down after between sunset and sunrise?
Well, two things. The question is who? The Cleveland Botanical Gardens, certainly.
Okay.
It is a charitable gift from a private donor. The terms of that donation have to be construed strictly.
So, but I get that. Just help me out. Can they close it or not? Can they close it or not?
Under the terms, under the terms,
can be closed at nighttime.
Under the terms of the donation, it cannot.
Cannot.
Council,
So,
let me ask you.
and they have to have, can there be any part of it that's not continuously open to the public? I mean, could they put a restaurant in there, or could they put a bathroom that's locked sometimes?
Your Honor, you're giving a number of hypotheticals that are not in the record.
I understand, but that's why we ask hypotheticals.
Well, I understand.
Trying to understand what your definition would mean. So
The issue here is that we've had 70 years of cooperation with the Cleveland Botanical Gardens in the city of Cleveland. There have been instances where in the past where there has been some difficulty in complying with the terms of the grant, where the parties have worked together. What has happened here is that the parties are not working together, and 11 acres of the grant, almost a seventh of the grant, is being closed off to the public.
But
and
the
it's being used
issue,
raised-
I'm sorry, but the issue is really just what the phrases in the, it doesn't really, the issue really isn't cooperation, right? It's what the deeds, it's what. the
Yeah, and
deeds. So
frankly,
help me understand, could they close any part of it off at all?
not according to the terms of the grant.
So every inch of it has to be available to the public for free 24/7.
It needs to be open at all times to the public.
I mean,
Council,
so
let me ask it a different way.
Sure.
If the Botanical Gardens 11 acres were open the same time the rest of the park was open, would that meet what the heirs want?
Yes,
Would that meet what the deed says?
yes. The rest of the park is open with certain exceptions that I can get into, which involve agreements with my clients. Yes, if the Botanical Gardens was open as the rest of the park is, yes.
Mr. Fillerhoff, can I ask a question? Well, one, I had a question too about the park's ability to regulate, the city's ability to regulate closures of parks. And I wasn't sure exactly whether that dealt more with curfew, which would be imposed everywhere in the area, even outside the park, which would naturally restrict access to the park, just based on the fact that you can't be in the city walking around a certain time, I guess. But another question dealing with the garage and paying and charging fees for the garage. Does the deed, or I think Mr. Wade anticipated an underground facility to charge? I mean, you can go to the park and not have to park in the garage. And that's under the park, which doesn't restrict access to any part of the park above ground. So is that really a similar analysis?
If I can address that, it is the underground. It is part of the gift. It is covered by the terms of the grant. The issue here
But the garage wasn't there at the time of the grant.
No, it wasn't. But the issue here, and I'm not saying a garage can't be there, but the garage is there, as is detailed in the record, for the purpose of raising money from non-park users for the benefit of the Cleveland Botanical Gardens. And in this case, the requirement under the grant is that the property be used for park purposes and no other purposes. And what is occurring here is that is another purpose. The purpose of providing an endowment for the Cleveland Botanical Gardens at the expense of the beneficiaries is a violation of the requirement that it not serve other purposes beyond.
So the garage is okay. So having the garage is okay, and charging is okay. It's just a matter of where the money goes.
Is well, there are two things. I'm talking about two different parts of the agreement. There is the part of the agreement that says open at all times, and whether the garage isn't open at all times if there is a gate and they're being charged admission for that. It's the same as walking into the 11 acres. Obviously, the 11 acres is a much bigger impact on the ability of the beneficiaries to use the property that was given to them by Jephthah Wade.
But to
How could
refine
there
that,
be
Mr.
any-
Kellerhoff,
How could there be any envisioning of using what's beneath the park by Mr. Wade?
There was no envisioning, presumably, I don't know, obviously, of what was beneath the park. But still, what is beneath the park is part of the park and part of the grant. And if you're asking me, in applying the grant strictly, whether it applies, I'm applying the terms of the grant to your question. But the garage, again, is using the park to provide funds for the benefit of the Cleveland Botanical Gardens.
but
The
Mr.
whole reason,
Kellerhoff,
go ahead.
With that garage, I mean, some of that was paid for, I think, with bonds. So if the only people who were being charged to use the garage were people who were using the park, and you didn't have, for instance, monthly subscriptions from people who worked nearby and found it convenient to park there during the week, would that be a problem for the heirs? Because, you know, this was deeded in the horse and buggy days, and now we're in a different time.
It was deeded in the horse and buggy days, but the record here, but first, there are two things again. First of all, the record is that the Cleveland Botanical Gardens was advertising the use of the parking to other users, Case Western Reserve. It is a money-making operation for the benefit of the Cleveland Botanical Gardens.
Let's say they stopped doing that and only patrons who were using the park and needed a place to park were being charged. Would the heirs still have a problem with that?
That would not be that much of a problem. But again, the question goes to the money, because even if the bonds are paid off, then the money still continues to go to the Cleveland Botanical Gardens for its benefit, for the purposes that we've already outlined in the briefs. They're trying to raise money for, and this is the issue. The money right now, based on the record as it is, we weren't entitled by the court's ruling to ask any questions and get any discovery about where the money went. But in deposition, we obtained testimony that indicated that the money was going to be used initially to pay off the debt for the construction that occurred there, and also was used to increase, as a device to increase the membership of the Cleveland Botanical Gardens.
Well, if the money,
No restriction.
Mr. Kellerhoff, if the money is separate and discrete, I imagine there's a way to segregate admission fees and parking fees. So if the parking fee money was used to pay for the construction and the maintenance of the garage, is that acceptable?
That could be acceptable. That would be consistent with some of the cases that we provided. It would be consistent with the thought pattern in the Inc. case, which wasn't really addressed on these terms, where the proceeds from an eminent domain sale would only be maintained by the city if those proceeds went to park maintenance.
So if the construction was paid off, the maintenance was paid for, and there was excess, it was extra revenue derived from parking fees, where should that money go?
That would need to go for the benefit of the park. It would be a wholly different matter, but it would need to go for the benefit of the park, not a separate private entity, the Cleveland Botanical Gardens, which, by the way, is now also controlled by Holden Parks, Holden, which is a larger entity. There is no control where that money is going to flow to after the debt is paid. That money can go anywhere, and that's part of the problem. It is not a park purpose. It is a Cleveland Botanical Gardens purpose.
Thank you.
Thank you, counsel. You've used your time. Now we're going to hear from, is it Mr. Lavasser for 8 minutes?
Good morning, Chief Justice O'Connor, and may it please the court. Eric Lavasser on behalf of the appellee cross appellant, Cleveland Botanical Garden. Your Honors, I'll be splitting my time this morning with my colleague from the city of Cleveland, Stu Hastings. I'll be addressing the issues regarding the Wade deed and the park use restriction at issue on the Wade defendant's appeal. Mr. Hastings will then be addressing the issues related to the Marketable Title Act at issue on our cross appeal. We would like to reserve 2 minutes for rebuttal on the cross appeal. Concerning the Wade defendant's appeal, in this case, the trial court and the Court of Appeals did nothing more than look to the admittedly clear and unambiguous terms of the Wade deed to determine that the Cleveland Botanical Gardens operations in Wade Park comport with the Wade deed's park use restriction.
Well, counsel, let me follow up then on my other question. Are there hours that the park is open and the botanical gardens are not?
Your Honor, the park as a whole, there are no hours. There are hours of operation for the botanical gardens.
So the botanical gardens hours are a subset of the total hours the rest of the park is open.
I believe that would be fair to say, Your Honor.
Okay, thank you. So the botanical gardens are not open at all times.
No, Your Honor, I guess that's where we would disagree. We believe that the botanical gardens absolutely are open at all times to the public, consistent with the requirements of the Wade deed. The construction in this case that the Wade defendants seek to put on the Wade deed is that the one reference in the deed to open at all times to the public necessarily means, as Justice DeWine pointed out, 24/7, 365. It's a reference to hours on the clock, as the Wade defendants would have it. Your Honor, we believe that is an unreasonable construction of the deed. And wholly
that's why I asked the question earlier, if the botanical gardens are open the same hours as the park is, would that be acceptable to the heirs? And your opposing counsel said yes. So, but right now, the botanical gardens are open fewer hours than the park is open, correct?
That is correct, Your Honor. But again, it would be our position based on the case law and based on the Wade deed itself that the botanical gardens can maintain hours of operation and still be open at all times to the public.
Well,
Again,
let me interrupt right there too, because aren't there times when there are private functions going on at the botanical gardens that would not allow the public to enter? And I know it might be rare, but doesn't that happen?
yes, Your Honor, there are certain times at which, for example, I think the Wade defendants know that there are occasionally weddings held at the botanical gardens. However, it would be our position that something of that nature would not vitiate the public use at issue in this case.
Why not?
Because, Your Honor, the public still has access to the park. The issue in the Wade deed is, does the public have access to the park? It does not require, as the 8th District appropriately recognized, that there be 24/7 absolute access to every square inch of Wade Park. That's obviously where there's a difference of opinion.
Right, there's that issue, then there's the issue of the limited hours that the botanical gardens is open, which is, as Justice Fisher noted, is a subset of the overall hours. And then there's the even limited subcategory of when the botanical gardens is being rented out or used for private use, then the public has no access to it, even though the facility is open, and even though the park is open. So that vitiates the all-time element also.
Well, but again, Your Honor, I guess in our view, it goes to the issue of when you talk about the park and when you look at the language of the deed, where it speaks to the park being open at all times to the public, that is not a reference to minutes or hours on the clock or every square inch of the park being open at all times. In this case, the 8th District properly found that open to public use does not require the area to be open to everybody all of the time. And furthermore, that right of access is not absolute and may be limited. And in fact, Your Honors, we need look no further than the Wade deed itself. If you look at the Wade deed itself, it contemplates that there are going to be rules and regulations prescribed by the park commissioners at that time that would govern use of that park. In other words, Your Honor, this was never intended to be a free-for-all.
All right, counsel, is another way of saying this is that instead of the botanical gardens having to be open 24/7 for all people, they are open to the public for all hours that they are open.
Your Honor, I believe I would agree with that. Correct.
Okay, and you think that satisfies the deed language, that as long as the hours that the botanical garden are open, anybody from the public can come in, pay to enter, and that suffices?
Correct, Your Honor. And again, we believe that's fully consistent with what the 8th District found in this case, that there would be a distinction when you're talking about the public versus private nature of the use. It would be the distinction, say, between a public park, which is accessible to any member of the public, regardless of their status or standing, versus, say, a country club, which could try and restrict access based on certain qualifications to be able to access the area. That would be the distinction.
All right, Mr. Lavasser, if I can ask you real quick before you move on, then what justifies the Cleveland Botanical Gardens, Holden Arboretum, what justifies any entity profiting from the use of this land?
Well, Your Honor, the Cleveland Botanical Garden is a nonprofit institution. So respectfully, we would reject the idea that's been advanced by the Wade defendants that somehow this land is being monetized and that this is some type of big money grab. The admission revenue, Your Honor, if the Botanical Gardens, which did, as the Wade defendants note, undergo a significant expansion, if it did not have access to these revenue funds, Your Honor, there would be no way that the garden could operate in the form that it does today. And it's frankly never been disputed by the Wade defendants. This is one of Cleveland's cultural gems at this point that is open to the public. Your Honors, I see my time is running down here, and I would like to cede the floor at this point, unless there are any further questions.
I have one more. Just
Yes, Your Honor.
the relationship with the Holden Arboretum, that was a refinancing of the bonds. Was that a money-making activity for CBD?
That was not a money-making activity for CBG at all, Your Honor. In fact, I think it's fair to say that the Holden relationship was very critical to ensuring the survival of the Botanical Garden.
Thank you.
Thank you, Your
Mr.
Honor.
Hastings.
Good morning, Your Honors. Chief Justice O'Connor, and may it please the court, my name is Stuart Hastings, currently Assistant Director of Law for the City of Cleveland. I'm here arguing on behalf of the City of Cleveland and University Circle Incorporated. Before I address the Marketable Title Act, I just want to point out very quickly on Eric's argument, the deed does contemplate fences are in the deed, and the fences by their very nature will restrict access to the park during some of the time. And the other plausible and we believe more likely interpretation of open all times means more open in perpetuity rather than hours of the day.
But
getting back to the
fences don't comply though. They're not the iron wrought iron fences, right?
Well, the deed contemplates fences, and when the fences are facing in a certain direction, they must be wrought iron.
Okay, thank you.
The Marketable Title Act, Your Honor, the Court of Appeals made 4 fundamental errors in reading the Marketable Title Act. First, it failed to recognize the special treatment that the Marketable Title Act affords powers of reversion, rights of entry, and powers of termination retained in the root of title and specifically addressed in the second clause of Ohio Revised Code 5301.49A. Second, the Court of Appeals failed and erred in finding that Wade Park cannot be subject to a conventional land transaction, somehow making an exception not written into the Marketable Title Act for grants to public entities. Third, the Court of Appeals erred when it misapplied Ohio Revised Code's 5301.51B's continuous possession exception to Revised Code 5301.51A first clause. We believe the second clause makes the continuous possession argument irrelevant, but even if it were relevant, the continuous possession was misapplied because they piggybacked the Cleveland's continuous possession of the fee simple with the non-continuous possession of the reverter right owned by the Wade heirs.
Mr. Hastings, can you explain how, if my memory serves me correctly from reading the briefs, didn't the city always say to University Circle, UCI, and the Botanical Gardens, you have to get all the heirs permission to charge a fee, an admission fee. You do that, you're good, you're golden. And it seemed as though my impressions were that never happened. You never got that, but everybody proceeded anyway.
Well, Your Honor, we believe that was unnecessary. But again,
But how was it unnecessary when the city said it was necessary?
well, the city can make additional requirements to its tenants that are not related to the way deed. We can always have more stringent requirements in our leases that.
So you're saying that was a lease requirement?
That was yes, Your Honor, that was a lease requirement done out of an abundance of caution. Remember, we're dealing with a reverter right, which is a Demosthenes sword hanging over the city. You want to be super careful, even though good legal minds say it's not necessary. It's still better to get permission. And it's a matter of courtesy to the Wade heirs. I mean, this was a valuable gift to the city. I note in passing that just last Friday, USA Today declared University Circle the #1 arts district in the whole United States, something that Cleveland is very proud of, something Ohio should be very proud of. And the final reason to put things like that in a lease, of course, is to avoid litigation. You know, you don't want to, as we are in right now, litigation with Wade heirs. And again, when the possibility is one of reverter, every careful lawyer always tries to be super careful. So going and
Counsel, Counsel, to avoid litigation, who filed this lawsuit?
Cleveland Botanical Gardens filed this lawsuit, but it was in response to threatened litigation by the Wade heirs. And in fact, after this lawsuit was filed, 2 other lawsuits were filed by the Wade heirs. The fourth mistake that the Court of Appeals made in the Marketable Title Act was they misapplied the title transaction exception to the Marketable Title Act. And again, because of the second clause of 5301.49A, we first believe that that's not even applicable. And second, there was no title transaction within time period that would have been prescribed by the Marketable Title Act. Going back to the first error, 5301.49A, second clause, uses the word only, and only with regard to rights of reverter and powers of termination. The reverter right in the Marketable Title Act has given special treatment, and it says a reverter right can only, with no reference to whether it's in the root of title, with no reference to continuous possession, no reference to title transaction, can only be preserved in the matter described in section 5301.51 of the Act. That is the proper reading of the Marketable Title Act as it relates to rights of reverter, which is a case of first impression in this court.
Counsel, you're into rebuttal time.
Oh, thank you, Your Honor. I will save my time for rebuttal.
All right. Mr. Fellerhoff. You'll have to turn your mic on, sir.
Quickly on the MTA, the 8th District got it right. As detailed and as denied by the city, this property is subject to it is a trust. It is a trust that's created and governed by Ohio decisional law and by Ohio statute that finds that it is not a conventional land transaction. This property cannot be transferred. So there is no need to apply the Marketable Title Act to this property. Additionally, all of the arguments being made by the city on the MTA are inconsistent with this court's rulings on the MTA, and they require the insertion of additional words into the statute. Everywhere in the Marketable Title Act, it talks about extinguishing interest that existed prior to the root of title. Here, the reverter is in the root of title. There's no confusion in doing a title search as to whether the reverter exists or not. You go back and look at the deed transferring the property.
Mr. Fellerhoff, let me ask a question.
Sure.
Would there be, is it possible is a possible satisfactory solution to at least one of the issues in this case be that the botanical gardens can continue to charge an admission fee. However, they cannot restrict access based on that admission fee. So in other words, they can charge it, but if somebody wants to come in and not pay it, that would be fine.
That would be consistent with the deed. The deed requires access, open access at all time. The botanical garden.
Council, I thought, well, maybe I'm mistaken. Did you not agree that the language that it was open to the public does not preclude payment of a fee by the public to use it?
It doesn't preclude, and I think we're getting at this the reverse way. I think the question related to the reason the admission fee is being charged and the reason that
let's just stop right there. I'm not interested in taking it further because I think I understand what you're going to get at here. I just want us all to agree that open to the public does not preclude an admission charge.
It doesn't preclude an admission charge, but the admission charge that is contingent on entering the park is the problem.
I'm not saying the park, I'm saying the garden. Okay.
Garden is the park. Excuse me, I apologize.
Okay, you've used your time and now we have a little over a minute for rebuttal.
Thank you, Your Honor. Mr. Fellhoff mentioned that a trust somehow vitiates the Marketable Title Act with how it deals with rights of reverter. Those are very different property sticks. Whether or not there's a trust or that the city is required to hold the property in trust, totally different stick than the right of the heirs to take the property back. So that has nothing to do with it. We deny that there's a trust.
So was this property ever transferred by deed once it was donated by the Wade?
Yes. Parts of it were I transferred to the Cleveland Art Museum. Parts of it, I believe, were donated to the Veterans Administration for a hospital.
Okay. But those are not subject to this reverter.
No, Your Honor, we believe that none of the property should be subject to the reverter because the Marketable Title Act vitiated it. This is just a red herring that the Wade parties have thrown into this case. It is not relevant at all. And that's the only issue he addressed. I mean, we believe that the Court of Appeals got it wrong on all four applications. The leases that they rely on for the title transaction exception all occurred after the September 1964, which is the deadline date for the Marketable Title Act. The continuous possession, again, the Wade heirs have not been in continuous possession of their right of reverter, which is the relevant property stick. And finally, reading 5301.49A, the second clause, it applies to the root of title. It does not make an exception to that. It uses the word only as the only way that one can preserve the right, such as a right of reverter or power of termination.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you call a recess for 10 minutes, please?
The court will now recess for 10 minutes.
this morning is 2020-797, State of Ohio versus Jeremy Crawford. For the appellant, Mr. Gamzo.
Good morning, Your Honor, Chief Justice, Honorable Court. May it please the court, Jeffrey Gamzo on behalf of Jeremy Crawford, and I would like to reserve 5 minutes, please, for rebuttal. Mr. Crawford was charged in a 4-count indictment. Count 1 was murder. Count 2, improper discharge of a firearm. Count 4, having a weapon under a disability. And count 3, which is the one that we're here today, strictly speaking about, involuntary manslaughter, with the predicate offense for the involuntary manslaughter being count 4, the weapon under disability. He was found not guilty of murder, guilty of the other 3 offenses. And there's no question at this point that he was guilty, in fact, of having a weapon under a disability. He admitted on the witness stand, he testified that he retrieved a gun and shot twice in the air, which is in the street. That's improper discharge. He had the gun. He stipulated to the attempted drug deal, which was the basis for the weapon under a disability charge. He's guilty of those 2 offenses.
Counsel, let me ask you this question. Is there any concession or mutual understanding between you and the state as to whose bullets caused the death of the victim in this case?
There's no question. There's no clear answer. Mr. Crawford maintains that he was not the shooter, that the unidentified African-American person who was with him when he arrived at the scene was in fact the shooter of the victim. And
the Court of Appeals decision says that the police identified this person by name as part of their investigation. In the facts of whatever happened to this defendant, was he prosecuted?
I can't answer that question, Your Honor. I do not know. Possibly Mr. Ochaki knows. But regardless of the question in either case is whether a weapon under disability charge can serve as, or does serve, more precisely, does serve in this case as the basis for involuntary manslaughter as the predicate offense. It's not a question of whether he had a gun. He had a gun. There was a gun there. That's settled. But possession, having the gun, that's a but-for thing. That's not necessarily a proximate cause of the killing. And more to the point, having a gun because he was not allowed to, due to an attempted drug offense, is not the proximate cause, or more precisely, the death is not the proximate result, which is what the statute specifically says, not the proximate result of having a gun that he could not have because of that drug offense. The state.
So what does the reason for disability have to do with anything? Doesn't the statute require that the result, that the crime result from the disability, not the reason for the disability?
I would argue, Your Honor, that what the statute says and what he's charged with is having a weapon under a disability because. The because is a part of the statute, and it's part of the predicate offense of the statute.
Well, the only crime he committed was, it has to be the proximate result of another crime. The only crime he committed was having a weapons under disability. So it doesn't. The reason isn't part of the crime of having a weapons under disability.
Well, Your Honor,
He violated this, he violated the stat, what he violated was having a weapons under disability, right?
what he violated was having a weapon under a disability, but that's not
so
simply
isn't the
having a
question-
weapon. It's not simple.
Isn't
mean,
the question whether violating the prohibition against having a weapons under disability caused the manslaughter offense?
Well, first of all, the answer to that we would say is no. Having the weapon under a disability is essentially a status offense, and the fact of the status offense in itself does not cause the crime. Having the weapon may be a but-for.
Well, it's not the crime. It's just having having a weapons under disability offense includes using a weapon, right?
Yes, yes. But having the weapon under a disability is, regardless of what you do with it, is a status offense. And the status itself is not in the ordinary case, in anything like the ordinary case, when we would submit this falls in that category, is not the basis, is not the proximate cause. It's just a but-for cause. Yes, he shouldn't have had the gun. He shouldn't have used the gun to shoot in the air, which at the very least is what he did. And we would submit that's all he did. But the record is unclear. The Court of Appeals says we don't know.
Well, isn't the issue whether a reasonable jury could have found that the manslaughter charge arose from using a weapon? Because he was precluded from using a weapon, right? And whether the question is whether a reasonable jury could have found that caused the second offense.
A juror could have found that using a weapon caused death. Yes, I can't. Yes, of course. What we would submit is that using the weapon, that the charge, however, is not whether using the weapon, and you and I may just keep going back and forth on this, Justice DeWine, but that using a weapon, that it is the using the weapon under the disability, and that we submit is part, the disability itself is part of the predicate offense. And you can't just remove that and say, well, the offense is using the weapon. No, the offense is having the weapon, using it, or brandishing the various ways that one can improperly have the weapon. But it is the impropriety of his having the weapon, the disability, that is key to having a weapon under a disability, which is the predicate offense. It's not having a weapon, it's having a weapon under a disability. And you can't write the second half of that out without deleting part of the statute, which this court isn't supposed to do. That's a legislative act to change the statute. And that's the essence of the argument, that the offense is not merely having a weapon. The predicate offense is not merely having a weapon, it's having that weapon under a disability. And without some connection between the disability and the death, the predicate offense in this case, in the ordinary case, when having a weapon under a disability is the predicate offense for involuntary manslaughter, it's not going to, we would say it's improper. It doesn't satisfy. It is essentially a status offense, and the status, it may be a but-for cause of the death, but for is not a predicate, is not proximate cause.
Counsel, let me ask it a little differently. The way I understand the weapons under disability statute, the person knowingly acquires, has, carry, or uses any firearm or dangerous ordinance. In this case, he not just carried it, he used it, right?
Well, he certainly used it shooting up in the air.
Right.
I mean, whether he used it to shoot that's.
So, but my point is, I was trying to understand your status argument, because it wasn't just status that he had the gun there, it's he used it.
But it goes back, yes, fine. But it still goes back to the question of the status is the impropriety of him doing it, of him not having a right to have the gun and use it. He's not charged with he's not charged with involuntary manslaughter for an improper discharge of a firearm.
Mr. Gibbs, so he could have just brandished the gun and the result could have still been the same, that the other person became incited and shot their gun, correct?
Well, that perhaps. I mean, yes.
Well, do we know that?
Certainly that could be what happened.
Is that what's in the facts? Is there an indication that the shooter was incited by whatever the client did?
It's one of the things that the Court of Appeals actually, that the 8th District Court of Appeals.
The 8th District said could have been, but I mean, the fact that it was a full moon could have been. Are there any facts that indicates that the shooter, the actual person who shot the victim, was incited by anything Mr. Crawford did?
That's one of the Court of Appeals, when it said, we don't really know what happened, whether he shot him or not. If he shot him, then that's one thing. If he didn't, well, maybe he incited it, and that could serve. Yeah, his action. I'm not disputing that what he did may have been a proximate cause. The death may have proximately resulted from some action that Mr. Crawford took. What I am arguing is that the specific action, that the predicate offense itself includes the not just having the gun, but the disability. And the disability itself, whether it was from shooting the gun in the air and inspiring somebody else to shoot, or shooting directly, the disability is part of the predicate offense of having a weapon under a disability. And the disability has to have, in order for it to serve as the predicate offense, in order for it to be for the death to be a proximate result of having a weapon under a disability, there needs to be a connection of some sort between the disability and the death.
Counsel, what if we agree with you? What happens?
He's guilty of having a weapon under a disability, for which he was sentenced to, I believe, 3 years in prison. He's guilty of improper discharge of a firearm, which he was sentenced to 180 days. There's a firearm specification attached to the improper discharge, and so he's still going to serve some time in prison, but he's not going to be guilty of involuntary manslaughter.
Counsel, was your client tried on a complicity theory by the state? Was there a complicity?
It was a mixed possibility. He was in closing arguments, the state certainly argued, even if you don't think he killed him, he's guilty of complicity.
And what's the evidence? Well, I'll ask the state that.
It's once again, the evidence is, well, that if he wasn't the shooter, that he was involved in and started the arguments and kept them going and shot up in the air, and as the Court of Appeals said, as I guess it was Justice Bruner suggested, that may have been incited the other person to shoot the victim. But it keeps coming back to this. I keep coming back to the same point, which is that his status and the disability is not a proximate cause. And I've got about no time left.
That's true. That's true. So we'll move on now to Mr. Oshaki.
Thank you. Chief Justice O'Connor, and may it please the court, Cuyahoga County Assistant Prosecuting Attorney Greg Ochaki, on behalf of the appellee, the state of Ohio. I'll be sharing the last 5 minutes of my argument time with the Ohio Attorney General's office. The issue that this court accepted for review is whether in the ordinary course of things, having weapons while under disability can serve as the predicate offense for an involuntary manslaughter conviction. And the answer, based on the plain language of the involuntary manslaughter statute, is yes. The statute provides that no person will cause the death of another as the proximate result of committing a felony. In this case, Crawford does not dispute that he violated the having weapons under disability statute, which is a third-degree felony, when he reached into his car, pulled out a gun, and knowingly used it and fired it into the air. Under those facts and circumstances.
So, Mr. Ochaki, how is that then causing the death?
Well, Your Honor, under the facts and circumstances of the case, which the fact finder reviewed, we had a early morning hours dispute that started in a house. It was an argument with the appellant and a third person. The victim stepped in to protect the third person. They went out, the argument got heated enough that the homeowner told the victim, actually everybody, to take it outside.
No, I know all the facts, but how did Mr. Crawford's violating having the weapon under disability, whether it was in his pocket, whether he shot it in the air, whether he hit somebody over the head, some third person over the head with the butt of the gun, how did that cause the victim's death?
That caused the death because it was the issue is when you're in the middle of an argument and you pull out a gun, it's reasonable to the likely result is that anyone else that has a gun is going to pull their gun out and shoot it.
Maybe not. Isn't that like so tenuous as to be, it's like, wet toilet. I mean, how is that to say there's so many other things that could come into play? If the shooter could have actually intended to kill the victim. So then how is Mr. Crawford's disability even a part of the scenario?
Well, Your Honor, the ultimate finder of fact, the finder of fact here determined that that the shooting of the gun in the air did proximately result in the defendant's death. And that's not the issue that's before this court. I mean, the issue.
Counsel, can I ask you something about that? The state in its case in chief did present some evidence that Crawford directly shot the victim in this case through Angela Mann. She testified that he made an admission 2 days after the shooting that he shot, and then he later recanted it and said he just shot in the air. That's right?
That's correct, Your Honor.
So that, do you agree with me that that's the only testimony that gets the state by a 29 motion as to causation?
As to causation for aggravated murder, yes. There was
and the state, the jury found the defendant not guilty of murder. And how is it consistent then to find him guilty as having caused under the involuntary manslaughter charge?
Well, Your Honor, involuntary manslaughter is a lesser included offense of aggravated murder. And the jury presumably determined that Mr. Crawford did not intend to kill the victim, but that Mr. Crawford's actions caused, were a proximate result of the victim's death.
By causing another person to shoot the victim?
Correct. His friend is the person that he brought to the party is the one that shot the victim. And like I said, there was a situation here where you've got a group of people in close proximity to each other. There's threats going back and forth, and instead of getting in his car and driving away, he reaches in his car and pulls out a gun. And by brandishing that gun, he set a chain of events where it was when you pull a gun out in the middle of an argument, I think that's within the scope of the risk that someone's going to die. That's within the scope of the risk that you create.
So, Mr. Ozaki, if everything had happened exactly the way this played out, and Mr. Crawford had a gun in his back pocket, are the results the same?
If he does not brandish his gun,
correct, but he still has one, so he's in violation of the weapons under disability.
Well, then I think you have to look at under the fact finder has to look at under the facts and circumstances. Is that a situation that having a gun on your person creates the risk that someone's going to be shot? My opinion, I don't think so. I think it's an easier call when you pull your gun out and you fire it in the air.
I'm a little surprised at your argument this morning. I mean, it isn't. Couldn't the jury have found that the defendant's shot killed the victim? I mean, he didn't intend to, but he shot in the air, and isn't that a reasonable interpretation of the jury's verdict here?
It would be a reasonable interpretation, Your Honor. The fact is, we don't know who shot. I mean, we don't know who shot the victim.
Right, and so, if we're reviewing for sufficiency of the evidence, then the question would be: could a reasonable jury have found that by him violating the statute, using a firearm, that he caused was approximate cause of the victim's death? Right.
That's correct, Your Honor.
Okay.
Counsel, is there any forensics with regards to the gun and the whatever bullets they took out of the victim?
There was the forensics showed, Your Honor, that there were shell casings. I think there were 6 shell casings that were found on the scene. 4 that they determined came from gun A, 2 that came from gun B. The forensic examiners were unable to determine which gun caused or which bullets actually hit the victim, so that they were not able to tell which of the 2 guns was actually the gun that was shot and that killed the victim.
So how many bullets were in the victim?
There were two bullets that were in the victim, Your Honor.
And they came from the same gun?
I believe I don't think they can determine which gun the bullets came from.
Were the bullets so degraded? Is that what you're saying?
The forensic examiner could not determine. They were both 9. I think they were both 9mm.
Okay, all right. Moving on then. So what Justice DeWine just outlined, the jury could have found that there's admission that he fired his weapon. So that's a given for everybody's purposes. Whether he fired it in the air or whether he fired it at the defendant, the jury could have believed that he fired it at the defendant.
The victim. That's correct.
The victim. I'm sorry, the victim. Yes.
But,
yes,
but following up on Chief Justice's question, that doesn't make any sense with a not guilty verdict on the felony murder charge, count 1. If they made that factual finding that the defendant directly shot the victim, and you did present evidence of that, it just doesn't make sense then that they wouldn't find the defendant guilty of felony murder. It wasn't aggravated murder, it was felony murder, right?
That's correct, Your Honor.
Jury verdicts don't have to be consistent, right? That's the rule when we review for sufficiency.
That's correct, Your Honor. When you have multiple counts in an indictment, the individual counts themselves, each count has to be consistent, but they don't have to be consistent with each other.
Well, let me just get back to the weapons under disability. Sorry, I have a lawnmower nearby. If the Mr. Crawford fired the gun in the air, but was not under disability, could you think the reasonable fact finder still find that his firing the gun in the air resulted in the death of the victim?
I believe it could have, Your Honor, under the firing a weapon in the over prohibited premises, because he was standing in the middle of the street and he fired it. If they had thought that firing had caused approximately resulted in the defendant's death, yes, they could have.
But he wasn't charged with that.
He was charged with that, Your Honor. He was convicted of the misdemeanor offense.
Okay.
Right, so because there was a misdemeanor, could there still be a finding that firing in the air resulted in the, what? So you're saying a fact finder could still find that shooting in the air resulted in the victim's death?
Yes, Your Honor.
Even though the charge of firing near habitation was not a felony?
Correct, Your Honor. And under Section B of the statute, a misdemeanor can be, or if the jury had found that his firing, caused serious injury. If he had fired in the air and if they believed that the bullet had hit him, then maybe they could have.
No, you're right. Right, without assuming that the bullets fired from Mr. Crawford's guns were the bullets that went in the air and didn't hit anybody.
Under your fact pattern, Your Honor?
Yes, under the fact pattern of not being under disability, firing gun in the air, but those bullets not being responsible for the death of the victim.
I think they could have still approximately resulted in the victim's death. Yes, Your Honor.
But Mr. Ochaki, in order for there to be involuntary manslaughter, there needed to be the conviction of a felony. And so since the other was a misdemeanor, the only thing that was left to the trial court was the weapon under disability, correct?
That's correct, Your Honor. And the way we charged it, it was charged as the having weapons under disability was the predicate offense.
Right. You're well into the state's time.
I was going to say, if there's no further questions, I would just ask that the court affirm the decision of the 8th District. Thank you.
Mr. Blakely.
Good morning, Chief Justice O'Connor. May it please the court. I represent the Attorney General, and I'm here to clarify a few things. And I first want to draw the court's attention to the only issue that is before it. The question is not whether there's proximate cause, and that's so for 2 reasons. First, Crawford does not present that argument before this court. And second, my friend Mr. Gamzo just conceded that there is proximate cause. The only question before this court is whether a violation of the felon in possession statute can serve as the predicate offense for involuntary manslaughter. The answer is yes. It makes no difference whether the underlying offense is robbery, child abuse, or any other felony in the revised code. The only question is, did the defendant commit a felony? If the answer is yes, then so long as that felony is the proximate cause of a death, they are guilty of involuntary manslaughter. That's the end of this case.
Well, but the question is the proximate cause issue. Where do we get that connection? You're saying that without question he committed a felony, having a weapon, being under disability and using, brandishing, whatever, a weapon, and as long as it proximately caused. Where is that connection?
I'll answer your question in a moment, but first I do want to clarify that's not the question before this court. As Mr. Gamzo just said, there is proximate cause. Now, to the extent the court is interested in that factual...
I don't remember him saying that, but okay, go ahead.
To the extent the court is interested in that factual proximate cause question, the standard of review dictates the answer. Viewing the evidence in the light most favorable to the prosecution, could a reasonable fact finder conclude that Crawford, by starting a fight, escalating the fight, acquiring a gun, brandishing his gun, and firing it twice into the air, started a chain of events that resulted in the death of another? The answer is yes. And the reason why it's...
Mr. Blakely, there's foreseeability with proximate cause. And the actual activity that constitutes the felony is having a weapon while under a disability. The fact that he had it in his possession. So analyze that in the context of foreseeability that it would cause someone else's death just by the fact that his status was that he possessed a gun.
Sure. So it seems like you are regurgitating Mr. Gamso's argument, and I want to break it down.
I don't regurgitate anything.
I apologize, Your Honor. I want to break down that argument because it's a bit confusing. Let's start with the felon in possession statute. There are two elements. One, an individual must have previously been convicted of a felony. That's the disability component. And two, they must have, possess, or use a firearm. That's the second component.
My question is about foreseeability.
Exactly. And your question directly asks, how can one element of the underlying offense reasonably foresee that it will cause the death of another? But that's not what the involuntary manslaughter statute says. The involuntary manslaughter statute says that the commission of the felony must proximately cause the death of another. It's not differentiating.
The statute says no person shall cause the death of another as a proximate result of the offender's committing or attempting to commit a felony. And when you get into the case law from the 8th and the 10th districts, proximate results in this context are defined as results which would not have occurred but for the risky activity and which are within the risk of foreseeable results of such activity.
Okay, so the question then is it reasonably foreseeable that by having a gun and brandishing it in the middle of a street fight and firing it twice into the air, that it's possible that someone else might also have a gun and they might fire in return, or they might join the fight to help their friend and fire at the opposing party? That is reasonably foreseeable. It seems as though the court's getting hung up on the possibility of there being an intervening cause, but the mere existence of an intervening cause does not automatically sever the causal chain, and that's especially true when that intervening cause was set in motion by the defendant's own conduct. Plus, again, Your Honor is right. Reasonable foreseeability is the heart of proximate cause, but it doesn't need to be the most immediate next step. I want to point this court's attention to State versus Hall, 2017 Ohio 879. There, a mother left her child at home, and she was the proximate cause of her child dying in a fire due to her absence in the home. That seems pretty like a long stretch, but the court held that was the proximate legal cause. And so that's the same thing here. And plus, this does seem like a close factual scenario, and that's the reason why it's an easy case on appeal. The jury found that in these close facts, Crawford was the proximate cause. On appeal, given the standard of review, viewing light most evidence favorable to the prosecution, this should be an easy case on appeal. And I do just want to reemphasize again, that's not the question before this court. It's illegal.
Based on analysis too, you would then agree that if we were to find in favor of the state on this case and affirm the Court of Appeals, then the exact same fact scenario minus the shots fired in the air, Mr. Crawford bringing a gun, still violating the statute, disability statute, he could still be found guilty of the victim's death, involuntary manslaughter.
Potentially, I do think it would matter what the jury found in terms of how the mere possession of the gun played into the fight. For example, if they were just fighting on the street and it was a concealed gun that nobody saw whatsoever, I don't think that a reasonable fact finder could conclude that a hidden gun somehow, it would be reasonably foreseeable that someone else would fire the gun in response to a hidden gun. I don't think a reasonable fact finder could find that.
But, and I see your point there. Thanks for making the distinction. So, and if Mr. Crawford fired the exact same scenario now, but wasn't under disability, you say the facts still support a finding of his being responsible for the death. But then you don't have the underlying felony of having weapons under disability.
Sure, and that's because the involuntary manslaughter statute has two elements. First, do you have the disability? Second, were you the proximate cause? If you only have proximate cause but no disability, then the state would need to charge something else. But here, the jury found both elements. He was under disability, and they found, based on the evidence, the surrounding circumstances, it was reasonably foreseeable that by his conduct, he set off a chain of events that eventually resulted in the death of another. And again, just given the standard of review, that's why this court should affirm.
Thank you.
Thank you. Mr. Gamzo, you have used your time. We'll give you a minute.
Thank you, Your Honor. Very quickly, first of all, I did not concede guilt, but if I did,
I thought Mr. Gamzo, I thought the representation was that you conceded proximate cause.
I concede proximate cause I concede the possibility that a jury could have found proximate cause from the use of the gun.
Which is what we have here. That's what we have here, is the use of the gun.
That's not the question. The question is proximate cause from the improper possession and use of the gun. The improper part is the key. He's not charged, as he could have been, with improper discharge as a predicate to a lesser involuntary manslaughter B. He was charged because, and that would be a different question. The question here isn't the improper discharge. It's not the shooting of the gun, which he did at some point, one way or another, in the air to Mr. A, one way or another. The question is whether the weapon under a disability felony is what was the proximate cause, provided the proximate result, reasonable foreseeability, all those pieces. The disability is part of the predicate offense. And that's what the state and my friend, the Attorney General, both want to say that's irrelevant. The essence, the underlying offense that proximately caused the death, the indictment charges, the jury said, the Court of Appeals affirmed, was not that he had a gun, not that he used a gun, but that he was under a disability. And
Counsel, I don't understand how you can divorce his status as a felon of being under a disability, okay, a weapons under a disability status, with the use of the gun, and you'd like to, separate that. I don't understand how you can do that.
Because he isn't charged with using a gun to cause the death. He's charged with being a person who has no right to have the gun.
But a weapons under disability status is possessing or using. And here he met that definition.
He used the gun, but the fact that he had the status that said he couldn't use the gun, that's what the charge is that proximately resulted in the death. And that status that says you can't use the gun, you can't have it, you can't use it, that doesn't cause the death. It's the use, if in fact is the cause of the death.
Thank you. Gentlemen, we'll take the matter under advisement. You'll be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.